Chapter 9 is workers' compensation. Our objectives define key terms, discuss the history of workers' comp, including statutes and reform, state the purposes of workers' comp laws, discuss workers' compensation program funding and the ways that premiums may be purchased by an employer, define and discuss second injury fund, specify who is eligible for insurance coverage under federal workers' comp laws. Name persons entitled to be insured under state workers' comp laws. Determine the waiting period in each state before benefits begin. Describe the types of compensation benefits. Define non disability, temporary disability, and permanent disability claims. List signs of fraud and abuse involving employees, employers, insurers, medical providers, and lawyers. State when to report fraud or abuse involving a workers' comp claim. Explain two ways in which depositions are used. Explain the advantages of filing a lien. Define and discuss third-party subrogation. Describe workers' comp health and financial record keeping in medical practice. Explain the procedure of completing the doctor's first report. Name the contents of a progress of supplemental medical report. Complete workers' comp forms properly and discuss fee schedules. Discuss electronic claim submission and explain how to handle out-of-state claims. Describe actions to take in following up on delinquent workers' compensation claims. So we start with the history. The first workers' compensation laws were enacted in 1911. Today, all states have workers' comp laws. Workers' compensation is the most important coverage written to insure industrial accidents. Before workers' compensation programs, workers had to prove legally that injury was caused by work-related negligence. Workers' comp enabled injured employees to receive medical care without going to court. Under workers' compensation laws, a physician who is incorporated is considered to be an employee. Federal compensation laws apply to miners, maritime workers, and government workers. State compensation laws apply to employers and employees within each state. Laws do vary by state. Statutes relieve the employer of liability except for gross negligence. Statutes allow employees to be more easily and quickly compensated for lost wages, medical expenses, and disability. Laws address systematic abuse and fraud. They vary from state to state, and issues can include proof of medical necessity, pre-authorization for treatment, medical bill review, caps on vocational rehabilitation, and use of mediators. By the 1990s, legal and medical corruption and abuse resulted in record high levels of expenses for compensation of healthcare professionals, legal expenses, and other costs. Reform laws made it easier to prosecute system abusers such as physicians, lawyers, or employees. Laws placed greater emphasis on occupational safety to proactively prevent costly injuries. Other issues are listed in your textbook as well. The purposes of workers' compensation laws: to provide the best available medical care to the injured, ensure maximum recovery, provide income to the injured regardless of fault, reduce overall expenses, resolution time, and litigation, encourage employer workplace safety, and promote study of workplace accidents and hazards, and facilitate improvements. In the last decade, there has been greater emphasis on workplace safety and preventable accidents because proactively implementing safety measures is more cost effective for the employer and society at large than actually treating the resultant injuries. Self-insurance. Company pays for medical expenses instead of insurance premium. Employees covered by ERISA. Stop-loss provisions may be included. Program may involve reinsurance on large claims. Captive insurance plans usually serve smaller companies. Outside firms may administer claims processing. ERISA is Employee Retirement Income Security Act. Self-insured companies tend to be those with good safety records or few workplace hazards. Reinsurance, stop-loss provisions, and captive insurance plans administered by outside firms may all result in delay of claim payment if not pursued aggressively and knowledgeably. Because of the health reform in 2010, companies that offer health plans must allow their employees to keep their children on their plans until they are 26 years old. With the passing of the Patient Protection and Affordable Care Act and the Healthcare and Education Reconciliation Act of 2010, beginning in 2014, almost everyone is required to be insured or they will pay a fine. Large employers with more than 50 employees must pay a $2,000 per employee fee, excluding the first 30 employees from the assessment if the government subsidizes their workers' coverage. Managed care. Increased number of employees are seeking managed care contracts with preferred provider organizations and health maintenance organizations to insure their workers against industrial accidents and illnesses. Managed care contracts are not uniform and may limit the choice of providers. Managed care contracts use fee schedule based payments, require pre certification for certain procedures, implement hospital and medical bill review, and incorporate utilization review of medical services. Eligibility. Private business, state, and federal employees are entitled to workers' compensation coverage. A workplace accident that results in injury is covered. Illness or disease that results from environmental factors in the workplace is covered as well. The worker does not have to be injured at the work site to be covered. Workers' compensation covers injuries that occur while working, even if not at customary site or during travel to and from a business meeting. Occupational illness or disease can be immediate or delayed for years before becoming evident, for example, asbestos exposure. For coverage, federal laws, government employees such as postal workers and FBI agent, workers in Washington, D.C., coal miners, maritime workers such as longshoremen and harbor workers. Each of these groups is governed by specific laws and acts, such as the Federal Employees Compensation Act of 1908, Workers' Compensation Law of D.C. 1928, Federal Coal Miner Health and Safety Act of 1941, and Longshore and Harbor Workers Compensation Act of 1927. For state laws, provisions cover workers not covered by federal laws. Employer must purchase workers' compensation insurance from private company or be self-insured with adequate cash reserves. Employer must also have employer's liability insurance. The employer must report a work-related accident if required by state law. Penalties vary between states. Employer's liability insurance protects against claims for bodily injury to non-employees or damage to their property. State laws provide coverage for minors. Most are effective outside the state. Provides coverage for civil defense and other volunteer workers. And the employer and physician requirements for filing injury reports vary by state and territory. Minors may have special legal benefits in some states, such as double compensation. Firefighters, paramedics, policemen injured in the line of duty while volunteering are covered. The Second Injury Fund, also known as the Subsequent Injury Fund or SIF, covers employees with previous injury or condition who is injured on the job, encourages hiring of the physically handicapped, and allocates benefit costs more equitably. A second injury fund was established to meet problems arising when an employee has a pre-existing injury or condition and is subsequently injured at work. Second injury combines with pre-existing injury to produce a greater disability than before. The minimum number of employees varies by state and territory, and some occupations are exempted. For waiting periods, this is the required time period that must elapse before income benefits are payable. Waiting periods do not apply to medical care, which begins immediately. Benefits include medical treatment, temporary disability indemnity, permanent disability indemnity, death benefits for survivors, and rehabilitation benefits. Medical treatment includes hospitalization, medication, and prosthetic devices if indicated, and rehabilitation benefits can be medical or vocational for disabilities. Your different types of state claims, we have ND, non-disability, minor injury that requires medical attention but employee is still able to work. TD, or temporary disability, unable to perform work duties for a specific time period. And PD, permanent disability, unable to return to previous occupation because of residual disability. Temporary disability, the goal is to maximize functions as quickly as possible and allow the employee to return to work or modified work. Permanent disability, the physician's final report must state permanent and stationary, meaning that no further improvement is expected. Then a settlement or compromise and release is reached between the injured party and the insured for a total sum, and the case is closed. And adjudication is the rating of a case or the final determination. Physicians are responsible for determining legitimacy of work injuries and accurately reporting findings. All individuals who deal with workers' compensation cases must report suspicious situations to the insurance carrier. If the claim is knowingly fraudulent, fines may be imposed, licenses may be revoked, or imprisonment may result. Actions can be taken to have the case investigated further by personnel from the fraud division or referred to the district attorney's office. Healthcare professionals, clerical staff, or any others involved in the workers' comp cases are responsible for reporting potential abuse or fraud. OSHA, the Occupational Safety and Health Administration Act of 1970. This act protects employees against workplace health and safety hazards. Complaint procedure enables individuals to pursue enforcement measures in their workplace. Noncompliance with work standards by employers can result in fines, and this applies to most businesses. Fines for OSHA violations can be upwards of thousands of dollars. OSHA applies to heavy, light, and service industries, nonprofit organizations, churches, hospitals, and retailers. OSHA does not apply to federal employees, farmers' families, church employees engaged in religious activities, independent contractors, or household domestic workers. For legal situations, a medical evaluator is the physician who conducts medical legal evaluations of injured workers. They must first pass a special medical exam for certification by the IMC, Industrial Medical Council. They're hired by insurance companies or appointed by the appeals board, and they conduct unbiased assessment of the disability. If IMC certified, the physician is titled as Independent Medical Evaluator, Qualified Medical Evaluator, or Agreed Medical Evaluator. Specific evaluation and management, E&M codes, and CPT, current procedural terminology codes, may apply for these evaluations. Depositions and medical testimony. This is where they discover additional facts about the physician, patient, or other party about a case. Proceedings take place under oath, but not in open court. Findings may be used to impeach or challenge credibility of a witness on cross-examination. Findings may be used when the case comes to trial. The physician should be compensated for time spent preparing to be an expert witness, and all agreements should be signed by the physician and a lawyer. Sessions are recorded by a stenographer, shorthand, audio tape, or videotape, depending on the circumstances. Sessions can be conducted in the attorney's office, the physician's office, or another location. There is a CPT code 99075 available for medical testimony. Then we have liens. These are legal claims on the property of another for the payment of debt, null and void at the end of a specified time period. Subsequent or amended lien can be filed and should be signed by the patient, employee, and patient's attorney. The right of lien expresses legal claim on the property of another for the payment of a debt. Another term for lien is encumbrance. The physician's fee should be protected by having the attorney sign the lien and indicating that the physician will be paid directly from any money received in a settlement. The attorney should provide at least quarterly updates of case status. The advantages of liens: court recognizes written agreement, provides protection in the event of litigation, it ensures payment for medical services, provides inexpensive means to collect full fees. The judge determines if fees are reasonable when the amount billed is more than the amount allowed, and helps avoid problems with collections. Payment may not be received for a long time, but a lien ensures that if there is a settlement, the physician will be paid. If the physician submitted an otherwise delinquent account to collections, up to 50% or more of the fee could be lost. Third-party subrogation. This transfer claims from workers' compensation insurance carrier to a third-party liability carrier. It's used in events such as auto accidents where another party may be liable for the claims. Subrogated carrier has legal claim to reimbursement of expenses. To subrogate means to substitute one party for another. Subrogation is the legal term for the process of initiating a legal claim against another party, for example, insurance, to pay insurance claims. Medical reports. Health information record keeping. This is to maintain a separate medical record, maintain a separate financial ledger, keep appointments for occupational injury or illness separate from unrelated matters, and keep documentation or dictation for each appointment separate. Keep only records of exams and treatments that pertain to the occupational injury or illness in the special file. Enter only billing statements that pertain to the occupational injury or illness, and that will be sent to workers' compensation in the separate ledger. Terminology. Most workers' compensation cases involve accidents causing bodily injury. You should become familiar with anatomic terms, directional and range of motion words, types of fractures, body activity terms, and words that describe pain and symptoms. Fractures can occur from falling, blows, impact hits, a disease process, or direct violence such as a car accident. Healing may take months and depends on the location and the severity of the injured part, associated injury, and complications or infections. Reporting requirements. The employer's report. Employer must file the report within a specified time limit. It is required by law in most states. Time limit for filing of the employer's reports do vary from state to state. The medical service order authorizes a physician to treat the injured employee. A copy of the medical service order should be retained for the treating doctor's files. Written authorization with valid signature is always preferred. Any outside testing or treatment must be pre-authorized by the workers' compensation insurance company with the name and title of the person authorizing the service. The physician's first report. Physician must complete standard form or narrative letter after first exam of the employee. and the original should be sent to the insurance carrier. Copies go to the state agency, patient's employer, and in the physician's file. Every copy must be hand signed in ink by the physician. The copy retained for the physician's file is kept in the patient's separate workers' compensation chart. Progress or supplemental report. Supplemental report is sent to the insurance carrier after 2 to 4 weeks of treatment to note the current status. Subsequent reports can be in narrative form, such as a letter, and don't require completion of special forms. Progress report sent to the insurance carrier if there is significant change in prognosis or status. All reports should be copied in the patient's workers' compensation chart for the physician's file. Claim submission. For financial responsibility, workers' compensation insurance is billed for all expenses. The physician agrees to accept payment according to the carrier's fee schedule. Patient's health insurance information should also be obtained and filed in case of non-related medical expenses. No copays or deductibles are collected from the injured employee in a workers' compensation case. In some states, the employer may have a $1,000 deductible to pay per workers' comp case. If incidental conditions not related to the workers' comp injury are discovered by the physician during an exam and treatment, such as high blood pressure or high blood sugar, the physician may bill the workers' compensation carrier for that portion of the exam, but must code correctly and carefully with regard to the treatment of the injury. If treatment is indicated for the incidental condition, that portion of the exam becomes the financial obligation of the patient or the patient's private insurance plan. If the patient chooses not to be treated by the physician selected by the workers' comp company, payment of services may be denied by the carrier and the patient becomes the responsible party. Fee schedules may follow the Special Workers' Compensation or Medicare fee schedule. Some include maximum reimbursement amounts, and the employer, state agency, insurance carrier, or payer may audit or review fees. Maximum reimbursement accounts may be exceeded and covered in certain situations, such as special training or qualifications or usual fees. Additional documentation by the physician may be needed. The percentile of charge schedule, relative value scale schedule are some types of fee schedules. Fee audits help to enforce compliance with the agreed upon fee schedule. Electronic claim submission and reports. Carriers may have separate claim for workers' compensation, not a CMS 1500 form. Electronic system or telephone submission may be available as well. Electronically submitted workers' compensation claims and data must comply with state insurance regulations. Out-of-state claims follow regulations for the state in which the injured worker was hired. Obtain and follow out-of-state fee schedule for billing purposes. Company whose employees routinely travel to other states usually require employees to have workers' comp insurance in those states. Delinquent or slow pay claims. Phone the patient's employer to verify the information. Send a copy of the claim form and itemized account statement to the carrier. Phone the insurance carrier after 45 days and request expected date of payment. Send the employer the copy of financial account statement with the outstanding balance. And contact the state board if the employer fails to file the employer's report of work injury. Use a certificate of mailing form with the U.S. Post Office to send claim forms to the workers' compensation insurance carrier. If the employer does not complete the employer's report of work injury form, the workers' compensation carrier will not settle the claim. If there is no response within 30 days of requesting an employer to file this report, send a letter and documentation to the State Workers' Compensation Board or Industrial Accidents Commission. Our summary for this chapter: federal and state regulations require that employers have workers' compensation insurance coverage against on-the-job injury or illness and pays the premium for each of their employees. Workers' compensation programs are not included under the definition of a health plan as identified in the HIPAA statutes. Employees who work for federal agencies are covered by a number of federal workers' compensation laws. The Second Injury Fund, also known as the Subsequent Injury Fund, was established to meet problems arising when an employee has a pre-existing injury or condition and is subsequently injured at work. Each state's legislation lists a waiting period that must elapse before income benefits are paid. However, medical and hospital care for industrial injuries is provided immediately. Workers' compensation benefits consist of medical treatment, temporary disability indemnity, permanent disability indemnity, death benefits for survivors, and rehabilitation benefits. A non-disability claim involves a minor injury to which the patient is seen by the physician but is able to continue to work. A temporary disability claim occurs when a worker has a work-related injury or illness and is unable to perform the duties of his or her occupation for a specific time. A permanent disability consists of an injury or illness, impairment of the normal use of a body part, that is expected to continue for the lifetime of the injured worker and prevents the person from performing the functions of his or her occupation, therefore impairing his or her earning capacity. In a permanent disability case, the physician's final report must contain the words permanent and stationary, P&S, so that the case can be adjudicated or rated, settlement can be reached, which is called a compromise and release, or C&R, and the case can be closed. It is the responsibility of all individuals who handle workers' compensation cases to notify the insurance carrier of any fraudulent or suspicious situation. OSHA, the Occupational Safety and Health Administration, is the federal agency that regulates and investigates safety and health standards at work sites for the protection of employees. Depositions from the physician and the injured individual by the attorney representing the workers' comp insurance company are usually taken in permanent disability cases. The physician should file a lien in a workers' compensation case that has gone into third-party litigation, or if there is a question whether the case is compensable. A private health record should never be combined with an industrial case record because separate disclosure laws apply to each, and the workers' compensation case may go to court. The first report of an industrial injury must be completed by the employer and the physician and is required by law in most states. A medical service order given to the employee by the employer authorizes the physician to treat the injured worker. In workers' comp cases, all medical reports and forms are legal documents and must be signed in ink by the physician.